Welcome to this course on the EU and global governance. Today we are focusing on human rights and the rule of law in EU external relations. We are focusing on this course through the lens of some ongoing research which is currently done at the Leuven Center for Global Governance Studies. In this course on EU external relations, we will focus on human rights and the rule of law. After a first part, which focuses on legal principles and the question of which power the EU actually resembles when it addresses human rights and the rule of law, we go on to explore basic foundations and objectives of EU human rights policies, as well as its challenges and implementation on the ground. Furthermore, we look at the rule of law promotion of the EU and ask, again, which objectives and challenges can be identified. Finally, we conclude with a general assessment of the EU's human rights and rule of law policies. When we want to explore the guiding principles of the EU external action, we can start by looking at the Treaty of the European Union. In fact, all objectives of EU external relations are stipulated in the primary law of the Union. A transparent list of all EU external relations objectives can be found in Article 21 of the Treaty of the European Union. In Article 21 we can read that the Union's action shall be guided by the principles which have inspired its own creation and which it seeks to advance in the wider world. Amongst others, democracy, the rule of law, and the universality and indivisibility of human rights. In the second paragraph of Article 21, we find a long and indeed comprehensive list of objectives of the EU, and amongst many others you will see that the consolidation and support for democracy, the rule of law, human rights, and the principles of international law has a prominent spot on the top of the list. Basically, looking at the treaties, we could argue that next to the EU's vital interests, norms and principles like human rights and the rule of law become key objectives in EU external relations. Moreover, according to the concept of EU external governance, these objectives will not only potentially Europeanize member state foreign policies, but also, at least in theory, impact on non-member states and other international organizations. The question then obviously arises how we can model the EU as a power in its external relations. Across a wide range of so-called power approaches, the one of Ian Manners, normative power Europe, sticks out. According to Normative Power Europe, EU external action is based on a normative constitution. For example, its very own primary law, while the EU's external action is more or less shaped by what it has itself identified as guiding norms and principles. In practice, this would mean that EU external action takes form via norm diffusion, for example by using conditionality as a tool to persuade other actors. The EU's external action, as Manners has illustrated, will however depend on the EU's own power of example. That means it has to live the norms and principles, in our case human rights and the rule of law, that it would like to be adopted by others. If this coherence in EU external action is absent, the EU may well lose its credibility towards the outside world. In this respect, other concepts of power have highlighted conflicts that the EU faces in applying its own principles and norms. Against this background, let us now zoom into the EU's human rights policies. The EU's constitutional pledge to place human rights at the center of its external policies has placed a heavy burden on the institutions. Implementing such a cross-cutting agenda is indeed no easy task, as human rights are likely to be affected positively or negatively by just about every policy. This is true for internal policies which the EU is applying to itself, its member states and citizens, but also in external policies. From a programmatic perspective, two documents have tried to systemize the mainstreaming of human rights in EU external policies. the joint communication of the European Commission and of the High Representative of the European Union for Foreign Affairs and Security Policy of 12 December 2011, entitled Human Rights and Democracy at the Heart of the EU External Action towards a More Effective Approach, which presents the challenges of the EU's pledge. Increasing questioning the universality of international human rights norms, problems of implementation, notably from the point of view of persisting discriminations against vulnerable groups such as women and gays, problems for the EU to be coherent, that is, to make sure that all its policies pull in the same direction, one that promotes rather than harms human rights, and consistent, that is, to make sure that the EU policies are applied in the same manner irrespective of who the third country partner is. Challenges associated with globalization, such as the emergence of new electronic communication technologies or of new non-state actors. The joint communication then also identifies the objectives of making EU human rights policies active, effective, and coherent, and the response that the EU will seek to bring to those challenges. The joint communication finally proposes a roadmap following three main signposts: bringing coherence in the communication words joining up into the different external policy areas which may impact on human rights, such as crisis management, trade, development cooperation, etc. Achieving human rights objectives through bilateral but also multilateral partnerships with key regional and global institutions, most notably the UN. Harnessing the collective weight of all the EU's institutions toward achieving solid results for human rights promotion. In terms of turning these broad orientations into an actual strategy, the Council of the EU has adopted the EU's strategic framework and action plan on human rights and democracy, which identifies 7 key principles, the strategic framework for human rights promotion, to be put into practice through 36 targeted actions, each time with a theoretical timeline. It is impossible here to detail all the strategic principles and actions, but you can find this graph in high-resolution detail on the website. On the ground, all these pledges, policies, principles, and actions with regard to the promotion of human rights worldwide take a variety of forms. One can distinguish between EU human rights activities which directly and solely concern human rights and those which, though they concern other objectives, are designed in a way that they can also positively impact on human rights. Examples of specific human rights activities and instruments include the following: diplomatic actions in third countries, and those representations use diplomatic tools such as démarches or meetings to promote human rights. When confronted with grave violations of human rights by a third country, the EU may adopt restrictive measures in the context of CFSP to react to those violations, such as the freezing of assets, embargoes on certain goods, or travel bans for the individuals or entities responsible for those violations. In its bilateral relations with certain partners, the EU has sought to establish dialogues and consultations to openly discuss challenges and possible progress for human rights. Multilaterally, the EU engages with a number of other organizations, either regional, such as the Council of Europe, or global, most notably the UN, to coordinate policies and join forces regarding human rights promotion. The EU also has a specific instrument, the European Instrument for Human Rights and Democratization, which consists of a fund with an amount of more than 1 billion euros that can be used to support human rights in third countries. Examples of policies which do not specifically concern human rights but are used as levers to support human rights are enlargement. Prior to joining the EU, candidate countries must meet the so-called Copenhagen criteria, which includes respect for human rights. Other partnerships and associations, such as the Neighbourhood Policy, the Eastern Partnership, or the Cotonou Agreement, which seek to establish wide-ranging collaboration between the EU and certain regions. Trade. The EU has a vast network of trade agreements in place, which are also premised on respect for human rights and also typically contain human rights conditionality clauses. This can pose problems in the negotiations, such as in the case of the agreement currently being negotiated with India. The EU is one of the most important development actors in the world. Its development policies include a firm human rights component, in the sense that the EU is trying to apply a human rights-based approach. As can be seen from this complex picture, the EU is only at the beginning of its process to ensure proper mainstreaming of human rights in all its external relations policies, but is working hard to try to achieve it. Still, criticism abounds along the lines cited above: ineffectiveness, incoherence, double standards. Therefore, for the EU, being a normative power is a constant challenge. Like human rights, the rule of law is a cross-cutting issue in both EU internal and external policies. It is nevertheless arguable that the EU seems to have rediscovered recently the virtues of the rule of law as one of the key values on which the organization was founded. Part of the reasons are probably linked to the recent systemic rule of law crisis that the EU has faced in some of its member states. These crises have, in fact, inevitably affected the EU's rule of law promotion. When analyzing the rule of law promotion as a strategic priority in external relations, we need to understand which kind of rule of law the EU advocates in a context where the European Union member states have developed very diverse rule of law traditions. For example, the rule of law, Rechtsstaatlichkeit, État de droit. It is arguable that the EU promotes a substantive version of the rule of law that goes beyond the simple protection of the principle of legality and is also closely intertwined with the promotion of democratic principles and the protection of human rights. Another difference with the promotion of human rights in its external policies is that there is no document that tries to systematize the mainstreaming of the rule of law in EU external relation policies. This absence of systematization and the lack of clear definition of the rule of law in EU policy constitutes a challenge for the promotion of the rule of law in EU external relations. This absence of systematization and the lack of a clear definition of the rule of law in EU policy constitutes a challenge for the promotion of the rule of law in EU external relations. In that context, it is hardly evident from the current EU policies whether the rule of law is only an annex to democracy and human rights promotion, or if the rule of law is intrinsically a subject and goal of EU external relations. Another challenge comes from the existence of a very diverse perspective on the rule of law around the world. In that context, the increasing tendency from the part of non-Western EU partners to reject the idea of transforming their societies according to European or Western standards partly explain the difficulties for the EU to promote its own perspective on the rule of law. Finally, the EU is also struggling to develop a coherent approach towards the rule of law, a coherence between the internal and the external dimensions, but also a coherence between the various dimensions of its external actions, being, for example, its trade policy, its development policy, or even its support to the UN's renewed efforts to promote the rule of law. At the same time, the objectives of the rule of law promotion in EU external relations are numerous, and most of them linked to the EU's willingness to promote legal certainty and the supremacy of the law. In addition, the rule of law constitutes a good entry point to reach other central objectives of EU external relations. In order to promote the rule of law, the EU mobilizes various instruments from its diplomatic toolbox. Soft instruments, conclusions, resolutions, declarations, statements, non-legally binding guidelines, human rights dialogues, EU special representatives' missions. Legally binding instruments. These instruments give positive incentives, so-called carrots, or negative incentives, so-called sticks, to comply with the EU principles, including the rule of law, for example GSP and GSP+. Suspension clauses. These clauses are regularly included in the international agreements with third countries and condition the implementation of the agreement to the respect of certain European values. Participation in international initiatives. The EU is deeply involved in the UN peacekeeping organization that is executing numerous missions with a rule of law component. And of course, the EU has launched its own rule of law missions, for example EULEX, the mission that supports Kosovo on its path to a greater European integration. To conclude, our presentation has shown that next to its fundamental interests, the EU is driven by principles laid down in the TEU. Moreover, human rights and the rule of law cut across all policies of the European Union and involve various institutional actors. At the same time, while the EU aims to systematize human rights, the rule of law remains less systematized. Also, the EU aims to mainstream human rights and the rule of law into its external policies, but coordination amongst the many institutional actors involved remains a difficult daily exercise. Hence, we also showed that the challenges which remain evident in and outside the EU pose questions on how to fulfill the objectives of the human rights and rule of law approaches. On this note, we need to ask whether the EU is able to deliver the power of example. In other words, one of the key questions for the EU to be answered are whether it can stick to its own obligation of coherence in order to avoid losing credibility on the international stage. Thank you very much for tuning in today and your interest in human rights and the rule of law.